The first case before us is State of Ohio versus Thomas Anderson. It looks like only the appellant is here to argue, so you'll have 15 minutes. You don't need to reserve time because you have 15 minutes straight. The argument is being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the name of children, minors, and victims during your argument. You can refer to them by initials or terms like the child. We've read your brief, and we're ready to proceed when you are.
Thank you. Your Honors, if it please the court, my name is Mark Ludwig. I was appointed to represent Mr. Anderson on this appeal, and I first note that young Mr. Anderson has now been a resident of Mansfield Correctional since October of 23. He was born February 12th of 2002 and was quite busy between June of 2020 and August of 23. These are three consolidated cases. There's an F4 receiving an automobile that arose in June of 2020. He was alleged to have acted alone. There's an F2, which I've called the drive-by shooting case, which arose in January of 22. There were two other defendants with him, one Rogers and one Suggs. There's a third case that's been consolidated. That's an F3 weapon under disability, which arose in August of 23. Hence, I say he was busy between 2020 and 2023. There was a fourth case that was mentioned at the sentencing. I've called that case the Baker-Ross case. Mr. Anderson attempted a delayed appeal, and his appointed counsel did that wrong in case 31-168. I mention that because the Baker-Ross case came up at sentencing in this case. He was sentenced in that Baker-Ross case to 18 months in September of 23. Assuming he's had no tickets, he's done and served that sentence, with jail time credit. Tomorrow, January 29th, he would be released. The statement of facts in this case, while the facts are important, this court's already addressed the background facts of the drive-by shooting in the Suggs opinion. And in this case, we can note that the state declined to address our stated assignments of error. The Suggs opinion originally was, I think Judge Lansinger, you were the author, and Judge Carr concurred. Judge Stevenson, good news is you're the new kid to this drive-by. We've asserted two assignments of error: breach of a plea bargain and ineffective assistance. The breach of the plea bargain is relatively straightforward and relatively simple. At the plea to induce his guilty plea, the state said, we will not ask for more than 10 years across 3 cases. At the sentencing, the state said, I know we're here for 3 cases, but I want to first acknowledge there was no previous discussion of this, but I'm going to talk about 4 cases.
On that fourth case, I know in the hearing, Judge McLaughlin said she would run it consecutive, but the order says run concurrent.
It does.
So is that harmless there then to run concurrent in this case?
Well, I think it exemplifies when the trial court was listening to what was said and what it recalled it was going to do. So I think at that point the trial court said, you know, he can ask for consecutive, but this wasn't part of the deal. But again, at sentencing, instead of not asking for more than 10, the state said, and I quote, I'm asking for 10 to 13 and a half years, plus the 4th case, Reagan-Tokes. Now again, that was a blank shot and may not have hurt him, but he's already been hurt by the 13 and a half years.
I guess the question is, going back to that initial recommendation, nowadays, when the prosecutors make a recommendation not pass more than 10, and doesn't say anything about Reagan Tokes, where does that Reagan Tokes fit in? Are we talking about the minimum presumed sentence supposed to serve under Reagan Tokes, which makes it 10, or as you're saying here, it's not really 10, because you got
really 10.
13 and a half in essence here, so you're looking at the maximum.
Well, I'm looking at the maximum, because I think I'm not gonna ask for more than 10 implies a maximum. And I think, I hate doing algebra to figure out, but we've come to that, to figure out what the recommendation would be. It's 120 months equals A plus 1/2 A equals, then you back into it. It came out to a basic of about 54 months for the minimum, and that works out to 120 months with the 3 years.
Counsel, I want to make sure too, in your brief, you refer to the promise that the prosecution made to your client as a cap of 10 years. Was that the actual language that was used?
Yes, I think we've quoted the transcripts accurately.
Okay.
Well, I guess, would we seriously be having this discussion if the prosecution had stood up and said, I know I'd ask for 10, but I want 50. Or if he'd said, I want 45. Or if he'd said, I want 40. I'm beginning to feel a bit like Abraham in Genesis 18, arguing with the good Lord about, well, would you destroy them if there were 50, if there were 40? The wrong occurs when he says 10 to 13 and a half. I think it's important.
Why didn't assuming that's correct, assuming that's not what they bargained for, there is a difficulty to me that counsel doesn't speak up and say, wait a minute, we bargained for 10 being the most under Reagan Tokes, and now you're saying 13 and a half, that's not our bargain, that's not what you said you would do.
Well, right or wrong, I think we've inserted that in our ineffective assistance claim. But in context, I can see how it happened. Anderson went second that day in pleading. Rogers went first. And in the Rogers transcript, where all trial counsel are sitting there, the state said, in a 10-year plea, and said, I'm capping it at 10 plus Reagan Tokes. Now, trial counsel for Anderson probably heard that. Her hearing's better than mine. But she probably heard that and didn't speak up, because when Anderson came to be sentenced, she probably heard that in the recommendation, because it had already been said. But that's speculation. This case should be decided on what was actually said. I find it fascinating that Mr. Anderson gets 3 plus 7 plus 3.5, 13.5. Mr. Suggs gets 3 plus 5 plus 2.5 for 10.5. He goes to trial. Ms. Rogers pleads, gets 3 plus 6 plus 3 for 12. Well, this sure doesn't seem like plea bargains reduce your sentence. I know there may be different facts, but they were all together. Now, the ineffective assistance claim, look, I hate these claims, but I think they're necessary to protect the record for later. This is not a results-based ineffective argument. If you look at the multiple counts that arose over 3 days and the multiple specifications that arose, I got a headache adding up what the maximums could have been. I think the max could have been close to 34 years. Guilty pleas, we acknowledge, generally waive an ineffective assistance claim, but where the record may support such a claim. Here, before the plea, there's 98 pages of pretrial transcripts with 14 different dates over these 3 cases, and there is not one substantive discussion other than, well, come back next time. In the plea, at that time of the plea in this case, the Suggs brief and oral argument had been held, and more importantly, the Suggs transcript had been filed in this court in November of '23. The record is silent as to whether that was ever reviewed by anyone. We've also added in the appendix the following. Appendix C indicates there was no probable cause determination at the municipal court level for arrest. Appendix, and again, there's no preliminary hearing in this case. Appendix F indicates that the attorney existed in municipal court, the same trial counsel, at the time that case was filed. Appendix H indicates there was no probable cause determination made at the municipal court level in the drive-by case. Appendix N indicates there was no probable cause determination made at the municipal court level in the weapon under disability case. Radovinsky, cited in our Rule 21, the Sixth Circuit made it clear that the federal floor is that after the fact grand jury action does not provide probable cause for the arrest. Now, whether new counsel, when this court vacates and remands, whether new counsel will determine to make those motions, I've laid out what I think they're worth. He or she can decide that at the trial court level.
Why is this not, though, covered by our normal rule of when you enter the plea, those things are waived? What is unique about this particular case?
What's unique about this case is usually the ineffective assistance guilty plea argument waiver occurs in the absence of a record which could support the ineffective assistance claim. As I've tried to detail now and in our briefs, there are at least 5 items that in this record that indicate there was support for such action. Your Honor, will it succeed? Would it succeed? I respectfully don't think that's your job at this point, but years ago, Mr. Sternberg and I had a series of arguments in this court in a civil case, and Richard started one by saying, I don't know why I'm here, you're not going to do anything. And I thought that was one of the points I learned chutzpah. Richard had chutzpah. I hope with the same chutzpah and more respect, I say, we want you to do something about this. We want you to vacate and remand, not resentencing. Don't become a sentencing trial court that corrects errors. Don't remand just for the trial court to resentence. We deny Mr. Anderson his right to seek a remand, to vacate his plea because this plea bargain was breached, if the remand is just that.
But counsel, with plea bargains, you know, the case law has talked about them being contracts, and usually you have specific performance. So if we remanded it back, we would remand it back for specific performance.
I think that's wrong, Your Honor, and I urge you not to do that.
I understand what you're
For the
saying.
very reason it denies him the right to move to withdraw. Had someone spoken up at the sentencing hearing and said, wait, that wasn't the deal, I want to move to withdraw, he'd had that opportunity to be heard. When you resentence or remand limited just to resentencing, you deny him that opportunity. It's not my call. God willing, I will not be trial counsel. It's not your call. That option is for Mr. Anderson and his new trial counsel. I think it's interesting, the state cited the Adams case, and at paragraph 29 it notes that SCOTUS had added a prong to the plain error standard that wasn't in the Ohio standard. That's the plain error including fairness, integrity, and public responsibility. This is my last criminal appeal on my retirement. You'll have to bear with me one more time in February in a civil case. I look at those pictures and I see 20 of them at least, starting with Judge Victor. And not disregarding this court, but of those 20, Judge Sam Bell and Mary Cassiopa taught me this: we must avoid the appearance of impropriety. What we have is our word, full and frank. I don't think the state got up in the morning twirling its mustache saying, I'm going to break my promise. I think it misspoke. But that's a violation of being full and frank.
Well, counsel, I have not at this point read the full transcript, which I will do. But in looking at the transcript pages that you cite in your brief, it seems to me that the prosecutor, I'm not saying he was vindictive or she was vindictive or anything, but it seems like they're saying, I'm going to go ahead and abide by 10 years, but at the same rate, I want everybody to know he picked up another one, and here I'm arguing that he should probably get more, even though I'll tell the court I want 10 years.
The picked up one already existed at the time of the plea bargain. In fact, he was serving his sentence. So it wasn't a surprise that happened. And secondly,
You're out of time, so if you could just take 10 seconds to wrap up.
what I have proven, I think, is what's written on my first grade report card. Mark talks too long, too loud, and too often. I thank the court for the privilege of appearing over these 50 years.
Thank you.